Hello, my name is Erin Gillia, and I am co-owner and founder of Montage Legal Group. I'm here to talk to you today about collaborating with outside attorneys as a solo or a small firm and the ethical and practical considerations that go along with those types of decisions. As you know, being a solo practitioner or a small firm comes with certain challenges, and one of them is finding the talent that you need in order to grow your practice and continue servicing your clients in an exceptional way. So, a few of the ways that law firms manage and grow their practices are with forming lawyer relationships outside of their current firm. There are a few ways to do that, and I'll be talking about four of them. So, first, I'll be talking about temporary attorney relationships. So, that's contract lawyers, freelance attorneys. I'll also talk about of counsel relationships, what that means, and the definitions and the different considerations that need to go into that type of designation. I'll talk about co-counsel relationships, and I'll also talk about referral relationships. So, when it comes to these outside firm relationships, there are really no special rules that apply specifically to these areas. Instead, the overall rules apply. So contract attorneys, of counsel attorneys, law firms, etc., they all have to follow just the regular rules of professional conduct, business and professions code, and all of the typical ethics rules and statutes that go along with those. In addition, we have ethics opinions that give us guidance and discuss different ideas. There are a lot of gray areas because, as I mentioned, there are no specific rules that discuss these types of relationships. In particular, it's just overall rules that will apply to these situations. So contract attorneys that have been around forever. Clients and firms have been using them for a very long time. And now, but the definitions, or at least the concept of contract lawyers, has changed quite a bit over the last decade. In the past, a contract lawyer might have had a somewhat negative connotation attached, meaning someone who maybe couldn't find full-time legal employment or had some type of other issue. But now, with the world of technology and remote working options and alternative arrangements and other things, there have been a lot of people who have taken up contract lawyering as just an alternative lifestyle choice in order to continue legal practice as opposed to the traditional type of employment. And similarly, law firms have really been capitalizing on this resource because it can be really difficult to ramp up in times that there's an increased need, especially when law firms don't always have that perfect information about when something is going to get very busy versus when something's going to go away, settle, or a deal might die or other things. So working with remote lawyers has become increasingly popular. So I'll be talking about some of those issues today. As I mentioned, there are several rules of professional responsibility that apply to an outside attorney relationship, and I'll be discussing many of them today. I'll be talking about the duty of competence. I'll be talking about diligence to your client, communications with clients, conflicts of interest, fees, the duty to preserve client confidences, and aiding and abetting the unauthorized practice of law, in addition to some practical considerations. The slides have outlined all of the different rules that may apply, and so you'll want to take a closer look at these types of rules. The first thing I'm going to talk about is what it looks like as far as working with a traditional law firm client representation versus bringing in an outside third-party representation or assistance for working with a firm. The traditional legal arrangement is just what you'd imagine. A law firm works directly with the client. Whereas if you bring in an outside option, then you have your freelance contract attorney or your of counsel lawyer who's working for the law firm while the law firm is working for the client. So you can see that there is now an in-between between the freelance attorney and the ultimate client. So what that normally would mean is that that contract attorney does not have an independent engagement with the client directly. Their agreement is with the law firm.